People in Texas and around our country think that there's a lot of what they call frivolous lawsuits, and that couldn't be further from the truth. Lawyers don't take cases that they don't think they can win under the law that are quote-unquote frivolous, because it doesn't make economic sense for the lawyer to spend his time and money on a case that he thinks that he'll lose. In fact, what's happened over the last 15 years from the tort reform discussions and from the frivolous lawsuit discussions is jurors walk into courtrooms and they're biased against the plaintiff. They tell us up front when we're asking them in voir dire questions that they don't believe in lawsuits and don't believe in pain and suffering. So it used to be where you'd walk into a courtroom and both sides were started at an even keel in a lawsuit or even base in a lawsuit, and that's no longer true. When an injured individual walks into a courtroom, the jury thinks they're there to play the lottery, the jury thinks they're there for something that is not justice. They think they're there to make money. And what they don't realize is when you spend time with people injured as a result of somebody else's carelessness or needless danger activities, but more like a careless activity or a DUI, the last thing that those people want to do is be sitting in a courtroom trying to ask the jury for fair compensation. They would much rather have their wife, their son, their child back. They would much rather not have the scar on their face from a dog bite. They would much rather not have had to go to the doctor 600 times or 50 times. They would much rather not have a permanent limp or a permanent back problem from a car wreck that was just caused by someone's carelessness in driving. Being in court and going through litigation isn't fun for anyone. And they wouldn't be there if they didn't feel it was just and right.